accommodations, workplace accommodations, and kind of how the real world works, and not just, you know, what you read or suggestions to you, from our experience representing people with these issues. I always like to first discuss who we are and kind of what we do. Sorry, that popped up on my screen. I just realized it. Well, first of all, I do want to say, you know, I am an attorney, but this material that I'm presenting today isn't legal advice. Every situation that anyone finds themselves in is, you know, always very different. And you can't apply everything to every situation. So if you do need legal advice, I recommend that you contact us, get in touch with us, and we can review your case more carefully. Today, we will introduce you to what we do. We will provide training about employment rights for people with disabilities and reasonable accommodations, and also provide a list of additional resources if you're interested in learning more about employment and accommodations. The Disability Rights of West Virginia is the protection and advocacy agency for West Virginia. A lot of people still don't know what protection and advocacy agencies are, but basically we are funded through grants provided by the federal government. There are several laws that provide protection for individuals with disabilities, and each state those laws require each state to have a agency, a protection advocacy agency. How does disability rights help people? Most of what we do is information and referrals. That's our biggest service that we provide. Basically what that means is that you can call, you can ask for help with a situation, or ask for information regarding resources, and we typically have a very large database of all kinds of different resources and services that we can refer you to. Being the protection and advocacy agency, one of our federal mandated duties is to investigate abuse and neglect. We investigate any reports of abuse and neglect we get. We can do that in facilities or in individuals' reports. We provide direct advocacy. What that means is if an individual has a specific problem, an advocate can be assigned to do things like attend meetings, make phone calls, write letters, provide information and education to individuals maybe who are part of the issue. We provide training like I'm doing right now on self-advocacy and rights. We have a very large list of trainings that we provide. We support self-advocacy. So sometimes we may do the direct advocacy, we may be the ones doing the work, but sometimes we will advise people on how to advocate for themselves so that, you know, once they're not our client anymore, they have more skills to address situations on their own. We can provide full legal representation. So we have 5 attorneys at Disability Rights. All of us are, you know, highly specialized in issues surrounding disabilities, and we can provide anything from advice and assistance with drafting documents to full-blown representation at trial. We also do systemic advocacy and litigation. So we do some class action work if we have to address a system-wide issue, and we also do systemic advocacy by being parts of boards and members. If we come across a systemic issue, you know, we will address it with maybe administrators of agencies or, you know, policy changes that are needed. There are certain things that we can't do. I always say almost every single one of these has a caveat where we can do it, but generally speaking, we can't do any family or criminal law. If it's criminal law, we can provide technical assistance to an attorney. So the reason we usually can't do much in criminal law cases is because counsel is already appointed through a court and we can't duplicate services. So in criminal law cases, if the attorney isn't an expert on disabilities and disability right issues that may intersect with criminal law, that attorney can contact us and we can provide, research, assistance, information, and advice. Generally, we don't do bankruptcies, probate of an estate. We don't typically just handle wills and estate issues. Personal injury, that one's kind of tricky because actually, abuse and neglect does fall under personal injury. So we do some personal injury, but I think the meaning of the slide is we don't do your typical car accident case. We don't do your typical slip and fall, kind of what you think about with a personal injury suit. We don't do the initial eligibility for Social Security benefits. We do have programs to help individuals who are employed or seeking employment with Social Security benefits, but we don't do that initial eligibility step. Establishing guardianship. It's very rare that we get involved in the initial guardianship proceedings if somebody wants to obtain guardianship over an individual with a disability. In order to do that, we would have to represent the person seeking the guardianship, and that's not what we do. Now, if somebody is having a guardianship filed against them, if an individual with a disability is having a guardianship petition filed and they want our help, we can definitely do those cases, and that is a priority of ours. Non-disability related issues. So, it has to be, what we deal with, it has to be directly related to your disability. The example I always like to give is, you need help because you're being evicted from your apartment. Well, if the reason that you're being evicted from your apartment is because you have a service animal and the landlord says you can't have pets, well, that is absolutely something dead within our scope of representation, and we will fully take on. If the problem is you haven't paid rent in 6 months, even though you may happen to have a disability, that's not directly related to your disability. Anybody can get evicted for not paying rent. So that's not something that we can help with. These were the laws that I was talking about earlier. I kind of got ahead of myself, that provide the mandate for protection and advocacy agency in each state, as well as give us our authority and access that we have to provide the services that we do. Each one is, for developmental disabilities, it's protection and advocacy for developmental disabilities, for mental illness, for traumatic brain injury. And then PAIR is the protection and advocacy for individual rights. And that one is what I call the catch-all law. Basically, it protects anybody with a disability who does not fall in one of the other categories listed above. We also have issue-driven programs. Protection and advocacy for assistive technology. We can help people find assistive technology resources if you're having trouble dealing with an insurance company or obtaining assistive technology from a school or while in a hospital. We can assist with those issues. The client assistance program is basically what I call the DRS complaint department. What the client assistance program does is we assist individuals who are having issues applying for or obtaining Division of Rehab services or services from the Centers for Independent Living. PABS is protection and advocacy for beneficiaries of Social Security. That is a program that is for individuals who are either seeking employment or are employed and are experiencing a barrier to employment. So if you receive Social Security benefits and you either want to work or you are working and you have some barrier that's preventing you from work, we can represent you on those issues. That is one of our best programs because we really can address a wide variety of issues. If you're having a problem with housing, that can be a barrier to employment because it's hard to keep a steady job if you don't have a steady place to live. We can help with criminal convictions that might be expungible under West Virginia law if that is a barrier to employment. PAVA is the voting program. Under this program, we do some monitoring where we go to polling sites and we do accessibility studies to determine if they are accessible. And if they are not, we work with the local county to try and make the sites more accessible. We also take calls and concerns. We can help individuals who are having a personal barrier to voting. And the last is the protection and advocacy for beneficiaries with representative payees. That is one of our newer programs, and it's a little different than our other programs. In most of our, in this case, what we do is we get assigned cases from Social Security to kind of audit and investigate representative payees to make sure that they are fulfilling their duties as expected. In West Virginia, we have two unique programs. They are actually wonderful programs and, unique to West Virginia. There was a class action lawsuit all the way back in the 1980s that addressed issues of abuse and neglect and discrimination that was happening with individuals who were institutionalized in state hospitals for having disabilities. These lawsuits required that individuals with disabilities be allowed to receive treatment and services in the communities, and that the state provide those services in the least restrictive environment. Under the Medley program, if an individual has been placed in an institution for more than 30 days prior to their 26th birthday, they can be assigned an advocate for life. And that person will basically, one of our advocates are assigned to them, and they will go to their meetings, they will check in on them, do home visits in order to ensure that they are not unnecessarily institutionalized and that their rights are being protected and they aren't experiencing abuse or neglect. Okay, so now that I've talked a little bit about who we are, does anybody have any general questions about who Disability Rights is or what we do? I see one question about service animals, and if we're talking about housing and emotional support animals, yes, emotional support animals in a housing situation, we can definitely deal with that. We can talk about service animals forever. So if anybody has any further questions about housing and service animals and emotional support animals, stay after the presentation and I'll leave the link open, or you can email me or give me a call at a later time. The ADA prohibits discrimination on the basis of disability. There are 5 titles to it, but the one we're going to discuss the most today is Title I, which requires employers to provide reasonable accommodations for applicants and employees with disability. The Rehab Act is the lesser known law that also requires that an employer provide reasonable accommodations to an employee who has a disability. It's an important law to be aware of, though, because the ADA does not cover every single employment entity. Federal government is actually not included in the ADA regulations. However, if you're a federal employee, you have the right to all the same anti-discrimination as somebody who is not a state and federal employee under the Rehab Act. The Rehab Act also prohibits discrimination on the basis of disability. It applies to any entity that is associated with the federal government, so is a federal government agency, or that receives federal funding. Many places, receive some of their funding from the federal government. And if they receive even 1% of their funding from the federal government, the Rehabilitation Act applies. It's also important to know about the Rehabilitation Act because it offers some remedies that the ADA does not if you do end up having to, sue an employer. Luckily, it's pretty easy to talk about both laws at the same time because the EEOC and the courts have ruled that all of the same kind of analysis applies. So anything that somebody's entitled to under the ADA, they are also entitled to under the Rehab Act. So you look at them almost exactly the same. Okay, so where exactly in the process of employment is it illegal to discriminate? Well, everywhere. So the ADA and the Rehab Act both say that in recruiting and hiring and the application process, job assignments, hiring, firing, enjoyment of benefits, leaves, layoffs, promotions, anything touching employment from the time a job is posted or recruitment is taking place to retirement benefits is all covered and cannot have any form of discrimination in those processes. So what is the ADA, the ADA doesn't actually say an employer is required to give somebody reasonable accommodations, but what the courts have all said and what the regulations say is that failure to provide an accommodation to somebody is a form of discrimination. So that's how we get the requirement for the employer to provide the reasonable accommodation. It is viewed as a form of discrimination to fail to do so. Excuse me. So what is accommodation anyways? So an employment accommodation is any change or adjustment to a job or work environment that permits a qualified applicant or employee with a disability to participate in the job application process to perform the essential functions of a job or to enjoy benefits and privileges of equal employment to those enjoyed by employees without disabilities. So that is a huge mouthful. So what does that mean? Basically, that breaks down to mean that an employer has to, make changes in the work environment, which is a different desk or a ramp needs to be built, or maybe emergency alert systems for someone who is deaf or hard of hearing need to be put in place. So it's any change in the physical environment that the person needs. It is also, however, a change in policy. If the employer has a policy that is discriminatory in nature, for example, employees are only allowed to eat at lunchtime and somebody has diabetes and needs intermittent snacks throughout the day, that would be a policy change that would be considered an accommodation. So what is the definition of a person with a disability under the ADA and the Rehab Act? Again, the definitions are almost identical. It is any person with a physical or mental impairment that substantially limits one or more of his major life activities. So if you have a health issue or if you have a condition that doesn't necessarily give you any functional limitations, then you're not qualified under the ADA for protection. But anything that does substantially limit one or more life function would qualify you. A person has a record of such impairment. So if you have maybe are not experiencing, if you have a disability that isn't, sorry, I am so much better at this in person. I am terrible when I feel like I'm talking to myself. So if you have a disability that maybe doesn't show up all the time, maybe you have a mental health condition like major depressive disorder, where a lot of the times you're fine, but you could have episodes. An accommodation might be required, even though right now at this moment you aren't experiencing those functional limitations. Person is regarded as having an impairment or treated like they have an impairment. This one doesn't so much apply to accommodations. So to actually obtain accommodations, you do actually have to have a functional limitation, and you do have to have, a record of impairment. But in other areas of discrimination, such as harassment or firing, if someone just regards you as having a disability, even if you don't, then you may still be protected under the ADA. So who is a qualified individual? So a lot of times what happens is there is a question either by the job applicant or the employer as to what is a person actually qualified. The employer may assume that a person with a disability just isn't qualified for the position, or an individual may assume they are not qualified for the position because of their disability. To be considered qualified under the ADA for a particular job, you have to be able to satisfy the basic job requirements. So if the job requires a college degree, that can't be accommodated. You can't ask that that requirement be removed. If it has specific licenses or skills that are necessary to do the job, then that's not something that can be removed. In order to be qualified, the essential job functions, you have to be able to perform all of the essential job functions with or without accommodations. So the essential job functions are usually a big sticking point and are a common point of contention among people with disabilities and employers. Many times, the employer will feel that if there is something in the job description, or if there's something they consider a essential job function, then the person cannot ask for a reasonable accommodation to either not do that function. But in reality, an employer can't just determine on their own what a essential job function is. They can't just declare something to be an essential job function. When evaluating kind of if something is an essential job function or not, you have to look at what are the tasks that are actually necessary to get the job done. And you have to look at a lot of factors to consider whether or not it's an essential job function. And the biggest one is the reason that the job exists, and the number of employees that are available to perform the function. If other people can kind of share one job function, and it doesn't cause too much issues in the workplace, that's something that a court will look at in determining an essential job function. The degree of experience or skill required to perform the function, the actual work experience of present or past employees in the job, the time spent performing a function, the consequences of not requiring that employee to perform the function, the terms of a collective bargaining agreement. So that is, a union. If you are a union employee, the collective bargaining agreements do control a lot of reasonable accommodation requests. The bottom line, though, is an employer's subjective determination is not the ultimate and final say as to what an essential job function is. And because this is kind of a complicated and frequently debated issue, I've come up with some examples here of past cases that we've addressed. The first example I give is, let's say, the city water department has two positions. One is somebody who delivers water pipes. The other one is someone who inspects water pipes, an engineer. Both job descriptions may require a driver's license. And, most employers will assert that a driver's license is absolutely a job requirement, and an essential job function, that if it's listed in the position description, that, you aren't qualified for the job if you don't have one. Well, that is not the case. So you have to look at what is the actual job that you're doing. an engineer might need to travel to a different location in order to do his job of inspecting the pipes, but his expertise, his background, his training is actually inspecting the pipes to make sure, you know, they're functioning properly. Driving is actually what would be considered a marginal job function, which is kind of a side function that goes along with what your, you know, what your essential job function is. And there are other things that the engineer could do to get to the sites and still perform the essential job function. He could take public transportation, a taxi, a car service. He could have a driver assigned to him to take him different places. So, you know, that's something that that's a job where even if the job description said that you had to have a driver's license, because it's not integral to what the engineer does for a living, they, you know, an employer could not refuse an accommodation for that reason or claim that the person is not qualified. Another example of a case I recently handled was a recreation area on a lake in West Virginia. The agency had jobs that was jobs descriptions for a supervisor and for rangers who worked there. Both job descriptions required a motorboat license. And when the supervisor became unable to participate in the motorboat licensing process, the employer attempted to say that he was no longer required for the job. He was no longer qualified for the job because it was a requirement, and that, you know, he had to leave that job for be demoted basically to a lower position if he could not obtain the motorboat license. His jobs as supervisor were administrative in nature. He had actually never operated a boat in order to perform any of his job duties. He dealt with making employee schedules, with personnel issues and project development and funding, budgets, that sort of thing. And, you know, the employer was trying to say, you know, he could no longer hold that position. However, since he never actually performed, you know, he never actually had to get in a boat and drive one in order to do all of his essential job functions, the employer ended up not being able to say that that was a job requirement and the accommodations had to be made. On the other hand, what would be an essential job function there is the ranger's job at that lake. You know, part of their duties every day is to patrol the lake via a motorboat. So a person would have to be able to maintain that license to be qualified for that position. So what is an accommodation anyways? We keep talking about how employers have to give you an accommodation, but we haven't yet discussed kind of what is the accommodation. Somebody tell me if I leave a chat up on the screen again. I just realized that was there. It is any change in a work environment or in the way things are customarily done that enables an individual with a disability to enjoy equal employment opportunities. There are typically 3 types of accommodations that are considered. There probably is more, but most of them fall into one of these categories. Modification of the job application process. So maybe when you go to apply for a job, there's a requirement that you fill out a paper application. But if you're a person who has a visual impairment or is blind, you may not be able to fill out a regular form. So the employer would have to find another way to assist you in completing that job application. It also applies to the interview process and you know, anything else that might come along with different application processes. Modification to the work environment. So as we discussed before, that's kind of basic. You know, there has to be assessed, the building, the office that you're given, the equipment that you're given, all has to be accessible to you. modifications that enable the employee to enjoy benefits and privileges of employment. So that might be, for example, if there is every day they give announcements in the morning, and those announcements, for employees are over audio intercom system. If an individual is hard of hearing or deaf, they would need to provide that same information to everybody. But this can also apply to benefits like insurance or retirement. If that information is normally provided in a non-accessible manner on how to obtain those benefits, utilize those benefits, that information also needs to be provided in an accessible format if requested. So some examples, which are absolutely by no means a limited list, but these are just some random examples, are making, the office space accessible, job restructuring. So maybe, changing duties around between several employees, part-time or modified work schedules. For example, a nurse may typically be required to stay over if they're needed because of a shortage or a call off and work 16 hours. If somebody has a disability and cannot work more than say 12, then, that is something the employer needs to accommodate. Modifying equipment, that's especially important. And, computers may need different software, or even construction materials may need to be modified so that an individual can use them. Tests, training materials, or policies. Again, if the format needs change for those things, or if a policy needs to be reconsidered because of its disparate impact. Providing readers and interpreters, and reassignment to a vacant position. So that's the one that, it has to be, if they're going to reassign you, it has to be agreed to by both parties. And it has to be the last option used. So the accommodations process typically takes place when, when the employer becomes aware of the need for the accommodation. Then the employer will either approve or deny it. If it's denied, the law requires that they engage in the interactive process, and then the accommodation should be ultimately implemented. So let's go through each one of these steps in detail. The need for an accommodation, which is what, initiates the process, is not, a lot of people assume that you have to ask for one. That's not necessarily the case. It can happen when either the employee requests the accommodation, or when the employer knows the employee has a disability and requires an accommodation to perform an essential job function. So you don't always have to say specifically, I'm requesting an accommodation. For example, if somebody approaches their supervisor and says, I might be late the next few mornings because I have medical appointments for a problem I'm having, that is usually considered the initiation of accommodations process. That is when the employer is becoming aware that the person has a concern, and that it might need to be addressed through a accommodation. In real life, this is where we're kind of navigating in real life the system. Most employers are not going to actually initiate the process once they have knowledge. Most employers are not going to even recognize that, your interaction with them or the information they have should be deemed as an accommodation request. It would be nice, but it just doesn't often happen in everyday life. So, usually if an issue comes up at work, the employers will usually try to handle the issue informally, or the worst thing that happens more frequently than it should is an employer will just assume the person is choosing, could do better but won't, or is underperforming for some reason that they can control or by choice. So they're just a bad employee and we should probably fire them. So to kind of avoid those pitfalls, some advice is, while you don't have to, disclose a disability and you don't have to request an accommodation, it is absolutely best to do it as soon as you think you might need one. If you notice you're having trouble doing something at work, or if you know a job function that you are quite possibly could need an accommodation for, it is best to go ahead and speak with your employer about it as soon as possible. You don't want to wait until there is an issue with your performance, or that you've been disciplined to bring it up. You want to make sure that you try to bring it up as soon as possible and make the request in writing. The ADA absolutely does not require that you make a request for accommodations in writing. However, I strongly encourage people to do so. It's just, if there is an issue later on, it makes things much clearer for both the employer and the employee. It's very difficult to kind of prove that an employer knew you needed an accommodation and failed to act on it if you don't have it in writing. If there is a policy or procedure for requesting a accommodation, try as hard as you can to follow it. Again, the ADA does not require that you follow a procedure. If your employer has certain forms they want, or a certain hierarchy you're supposed to follow, you don't technically have to do it under the law. You aren't required to do it in order to receive that accommodation. But it's best practice just because it makes less argument at the beginning of the process and allows things to be more agreeable. Does anybody have any questions up to this point? Say, I'm also much better in interacting during my presentations, so the Zoom has been hard for me to get used to. So if anybody has any questions throughout, just either use the raise your hand function or put it in the chat. Moving on to the medical documentation. So you're not necessarily required by law. Nothing says you have to provide medical documentation of your disability or your need for an accommodation, but an employer is allowed to ask for it. They're not allowed to ask for a huge amount of information, but what they are allowed to ask for is, medical documentation of what your disability is and what your functional limitation is. So it has to say, they are allowed to ask for something that says, Jane has, a issue with her back and it is caused by A, B, and C, and she cannot lift heavy objects, for example. I always recommend that people have that medical documentation ready. Even if you don't turn it in with your initial request, have it ready to go. What I've seen happen a lot of times is individuals will put that request in, the employer will come back and ask for the documentation, and then the doctor takes 2 months to get it back, or they can't get an appointment with their doctor quickly, and things at work are going downhill in the meantime while you're waiting for your doctor to get you the documents that you need. So I always recommend having that available beforehand. And like I said before, the employer can't request just anything. It is very limited in what they can request. The next step in the process is what, in legal terms is called the interactive process. That if an employer kind of isn't going to give you the accommodation right away, if they, if you go and say to them, I need a screen reader for my computer, and they say, okay, the IT guy will look into it and get it installed as soon as possible, then there's no real reason for an interactive process to take place, right? Everything's good. But if the employer is unsure of what accommodation to give you, or they don't, they want more information before they say yes, or they straight deny it, or they just say, no, we're not going to do that for you. The law requires them to engage in this interactive process. And what this is where the two parties, the employer and the employee, sit down and try to really identify what the specific needs of the individual are, what potential accommodations are available, and how to implement the accommodations in the most effective way for both parties. Like I said before, employers often will try to skip this step of the interactive process. They will try to just deny it straight up before engaging in the interactive process. Or what also can happen is sometimes employers will provide an accommodation informally. That is usually not a good idea. If your employer is providing you an accommodation, I highly recommend that you get it in writing. Because what can happen if you don't get that in writing is, I'm giving you an example here of a case that I covered. I had an individual who worked at a job that required 24-hour shifts. She had worked there for several years, was a great employee. Her manager knew that she had a seizure condition that was worsened if she had a distorted sleep schedule. So the manager and the employee agreed from the beginning, of her employment that she would not work night shifts. This wasn't documented anywhere. It was just the agreement between them, and it went on for several years. Well, that manager left and a new manager was hired. And the new manager decided, it wasn't fair that this person didn't have to work overnight and that everybody else did, and started putting her on the overnight shift. Well, there was no way to prove that she had been given this as an accommodation pass. It wasn't in writing. So we had to start all over at the very beginning of the process of requesting the accommodation and, getting the medical information and going through the interactive process of negotiating what was the best accommodation. So, if that had been put in writing to begin with, this employee could have avoided that whole mess. So if your employer is giving you the accommodation, but they're trying to do it in kind of a casual fashion, I would suggest politely asking that they put it in writing. I also recommend that you really document what happens, during the accommodation request process. Keep any emails, keep any text messages, keep any documents that you submit or that are given to you. That paper trail really does make a difference. And the reason is because of a lot of employers, what they get in trouble for is not engaging in the interactive process, right? Is just making a determination on their own without exploring other options or without talking to the individual about their needs, and just kind of denying the accommodation or saying, okay, well, we'll give you this, but not that. So really, I know nobody wants to think they're going to have a problem later on with an accommodation or an employment issue, but if you document just in case from the beginning, it can make it a lot easier for you to file a complaint later if you need to. If you feel like the employer has completely overstepped this, and you want to try something without having to involve a lawyer or an advocate, you want to try to work with them on your own, you think they might be reasonable, you may want to try submitting a written request for a meeting. A lot of times employers, especially in smaller businesses, they don't know about the interactive process. They don't know what they're supposed to do when somebody comes to them and requests an accommodation. And maybe they are willing to work with you, but they're not educated on this process and what their responsibilities are. So if they kind of deny an accommodation or don't react in the appropriate manner, I always recommend, sending them a polite letter saying, I'm requesting that we engage in the interactive process so that we can discuss what can work for both of us. Once you do kind of get into that process, I recommend that you have ideas about what accommodations you might need. It's not a requirement. The law does not say you have to go in there and say you need a specific accommodation. You don't have to go in and say, I need, this software specifically. You can just tell your employer the functional limitation caused by your disability and how it's affecting your work. However, I strongly recommend that people kind of know what's available to them if possible and where feasible. Because most employers are going to have even less of an idea than you about what you might need or what's available. And really, the person with the disability knows exactly what their limitations and strengths are, so they can evaluate what accommodations will work the best for them. Another issue that I see arise all the time is employers want the doctors to write, a letter or note that says, this is what the person has, and here is what they need, and here's what you need to do for them. Doctors rarely, if ever, will do that. And this causes usually a lot of back and forth between employees and employers. They will consistently, the employer will say, we need a more specific note, and the doctor will say, I'm not writing a more specific note. Doctors will typically just write very general statements about what the functional limitations are. Person cannot lift over 50 pounds. Person should not work more than 12 hours. They will not say you have to provide A, B, and C. So that's why it's another good reason to really have those accommodations in mind to prevent the employer from leaning too much on the medical documentation. I don't even know all the things, all the devices, technology, all the policy modifications that are available out there. I've been doing this for a long time, and I still learn something new every day. I learned about new devices this morning in the communications seminar that was given. So if you don't know what you need, a great place to start is the Job Accommodations Network, JAN. It's actually here in West Virginia, but it's a nationwide service that has huge data banks on what is the best type of accommodations for different disabilities, different recommendations, lots of information. So I say that is a wonderful place to start. There's a lot more resources that I'll talk about later, but that is a great place to start. I know of no better place to start. And undue hardship. Many employers will deny a request for accommodations because they will claim that it is an undue hardship to provide that accommodation. The ADA and the Rehab Act both say, if the request for the accommodation would cause an undue hardship, that the employer is not required to provide it. What does that mean? Well, the law says it means significant difficulty of expenses and focuses on the resources, circumstances of the particular employer in relationship to the cost or difficulty of providing specific accommodation. It may not sound like it, but that is a really high standard. A employer has to show that the cost of the accommodation, well exceeds their budget limitations. The bigger the company, the higher the standard for how much something costs. The more employees they have, the more resources they have, the higher the burden gets. Most accommodations cause very little, if any, burden on an employer. Some do, because some cause some, inconveniences, I guess, but most of them don't. Most accommodations I've been able to work with for people in employment really don't cause much of an issue for the employer. They just don't want to do it. So if the employer does say undue hardship, it's something, we can look at and see if that's actually the case. Some of the most common excuses I get that are claimed to be undue hardship by employers are morale of coworkers. Well, if this person doesn't have to work 16-hour shifts and I do, well, that's not fair. And, we're, going to look down on that person or have a problem with this issue. That's absolutely not a reason to not provide an accommodation. The whole reason for accommodations is to put individuals with employees on an equal playing field in employment. So, I advise employers and with those reasons for denial to say, while accommodations are confidential and I can't talk to you about it, you need to realize that things are done for a reason, and do your job and be happy. Consistency among all employees is another one I get all the time. I hear denials from most clients I get who have a denial of accommodation. If we have to do it for you, we have to do it for everybody. Again, that is the exact opposite of the specific reason that the ADA was enacted. It is to put people with disabilities on an equal playing field by providing accommodations. So if you provide an accommodation to a person with a disability, you're putting them on equal footing as their coworkers. You're not giving them an unfair advantage. You're not making things easier for them. You're making things the same. So that is absolutely not an excuse. And even policy modifications, like with the vehicle licensing case that I had, they kept saying, well, if we say he doesn't have to have a license, then we won't be able to require it for anybody. Absolutely not. A policy change, a requirement change for one individual who, that's provided under the ADA, there's no reason it cannot be applied to anybody else. If you make that accommodation for one person. Inconvenience, that's that's also the most likely reason for denial. Well, if I give you part-time work, I'm going to have to hire somebody else. I'm going to have to reschedule. Everybody's schedule is going to have to change to accommodate that. Well, if it can be done, it's not a hardship. If it's not insurmountable, then inconvenience is not a good reason to deny it. Lack of knowledge is not an excuse either. That's what the interactive process is for both the employee and the employer to do the research, talk to different people, find out what accommodations would be effective. I've had employers say, well, they may be blind, but I don't know of anything I could do that would allow them to perform this job. Well, just because you don't know doesn't mean it doesn't exist. If you are, in fact, denied an accommodation, one thing I did forget to mention earlier, I think, is that you don't have to be given the specific accommodation you ask for. So while I say it's a great idea to come in with a lot of options for accommodations, the employer does not necessarily have to give you that accommodation that you came in asking for. What they do have to give you is an effective accommodation. So if they offer something that allows you to perform that essential job function, even if it's not your choice of accommodation, that's good enough under the law. So that's also something that should be worked out in the interactive process. The employer may propose some things that they would like to offer, and the employee may propose things that they feel would help them. And if you aren't in agreement, then the process should allow some compromise to be reached as to what is the most effective option for both parties. If you do find yourself in a situation where you've done everything you could, you've done everything right, and you still are getting denials from your employer or in the job accommodations process, or if you feel that your employer isn't engaging in the interactive process or isn't going through the steps that they should to come to an agreement on accommodations, or if they tell you that you're going to get an accommodation but they don't provide it. Example I have of that is I had an individual who worked at a large department store. He was deaf, and his only means to communicate with management and other team members was via text messaging phones that they had given to everybody for him to use. Well, the issue came up is when nobody would turn them on or carry them with them. So, in his case, we had to, work with the employer, because while they provided the accommodation, they failed to implement it. They gave the phone to everybody, but nobody used them. So it was really ineffective. If you run into any of those type of situations, then you have options. One is to contact someplace like Disability Rights of West Virginia and you know, get an advocate assigned, maybe try to work with your employer to educate them, which you can do on your own too. You know, if you are getting a denial, maybe gather some resources to educate your employer if you feel comfortable with that type of relationship. But if none of those things work, then your options would be to go through the appeal process. A lot of larger companies have regimented appeals processes or grievance procedures for employment accommodations. That is the first step to take. And unfortunately, in employment law, it's different than most other types of legal actions. Under the ADA and the Rehab Act, you actually have to exhaust all of your options before you go to court. So if your employer does have a grievance or appeal process, you do have to use that first. If you use that system and it doesn't resolve the situation, or if your employer doesn't have a grievance or appeal process, which most smaller employers don't have that, there is the Human Rights Commission in West Virginia, and there's also the Equal Employment Opportunity Commission, which is the federal agency. You can actually choose to file in each one, but I would recommend, you know, if you want to do that, to contact somebody like Disability Rights or Legal Aid of West Virginia, and we can help you navigate which process is the best to go through. Okay, again, does anybody have any questions at this point? The rest is resources, and since I'm running out of time, I don't need to talk about those if there are questions. I am reading a question right now, so be patient. Okay, the first question I had is, if a person was hired into a position that did not initially require them to be on call overnight, but then the job requirement changed through a policy that required them to be on call overnight, would it be the employer's responsibility to accommodate a person with a medical condition that is aggravated by sleep deprivation? Those can be complicated issues, but I would venture the guess of yes, it should at least be considered. And if if it is not considered, if the employer is going to deny it, then they need to really evaluate the reasons. I would point you back to that big list of considerations that were on the slide previously, essential job functions. Because what the question wouldn't be is what the policy is. The question would be, or when it, because an employer can change what an essential job function is for a particular position. But if it's not an essential job function, if it doesn't meet all those requirements of an essential job function, then yes, they would be required to make that accommodation. You know, for example, if there is enough people who can cover the on-call overnights without causing too much disturbance in you know, operations, then they probably would be required to do that. So that is a more complicated question, and like I said, I would review all of those kind of essential job function analysis issues, and if you have further problems after that, you know, contact Disability Rights of West Virginia, and we'd be happy to look at the case. But that is one where I would say most likely the answer is yes, but it's impossible to evaluate every situation with little information. Okay. Does anybody else have any questions? I'm going to put my contact information in the chat in case anybody has anything that they think of later on. And if anybody has any questions, they can also stay on the call, but I believe I'm out of time. If anybody, I would recommend reviewing the resources that we put up here. I would love to be able to talk about all of them, but it's just not going to happen today. So questions, concerns, want to learn more, just either stay on and, turn your video on and we'll talk, or contact me at a later time, or contact Disability Rights generally. Okay, Madison, am I free to go, or do you need anything else from me?
I think we're all set here if you're about all wrapped up.
Okay, I didn't have any questions.
All righty, thank you for coming.
Oh, no